Hello. Hello, Your Honor.
Do you know what your lawyer had worked out for you to do, sir?
Today?
No. What you were supposed to be, what you were supposed to do between the last setting and today? What were you supposed to do?
He told me I needed to go to a mental health evaluation or something like that.
All you had to do was walk in, tell them that you're there to do it, and then they would have done the assessment.
Okay.
I don't understand why it never got done.
I would suggest not a reason because he's going to give you a week. That's my
Yeah,
suggestion.
that's all I need. Okay, so
Your case is 250 days old.
yes, sir.
Unacceptable that it's gotten this old.
I know, sir.
I will give you a week. If
Thanks.
you don't have it done in a week, I'm going to set your case for trial. And I'm not giving you any more resets.
Okay,
You'll be put to trial.
that's good enough, sir.
1 week.
Yes, sir.
If you
Yes,
don't
sir.
understand what to do, Mr. Newman can help you out.
That's why I
Just
Notice how the judge is giving the defendant one final chance here, just 1 week to complete a simple mental health evaluation. In legal terms, this is actually pretty generous. Judges often lose patience when a case drags on for over 250 days. What do you think? Should the judge have been stricter, or is he being fair here?
no more excuses.
Okay, yes, sir.
Thank you, sir.
Thank you so much.
Okay, sure. So,
I'm here today on Carl Lee Powell. He's in custody. It's a bail review setting. He has a felony attached, and I spoke to DVD about the situation. And it is a little confusing because it appears when he was in felony court, the residence that he's supposed to stay away from is actually his mother's residence where he lives. The complaining witness is like a roommate that he let a gentleman and this gentleman's girlfriend move in with him. And so
In her house.
in her house with the mom, with the mom. And then the allegation is that the complaining witness stated that he, assaulted her on a different occasion. And then that's when the charges were filed. So,
Complaining stated that Mr. Powell.
yes,
Okay.
assaulted her.
Okay.
And then charges were filed and he was given bond conditions. And at that time, like January 31st, a MOEP was signed. Okay. And he had an ankle monitor. But the complaining witness then went to a rehab facility for crack addiction, I believe. And so when she was out of the house, he goes back to felony.
This is where it gets legally messy. Bond conditions were amended in one court, but the protective order, the MOEP, wasn't updated at the same time. That means technically, Powell could live at his mom's house under bond rules, but still be in violation of the protective order. Ever seen a system trip over its own paperwork? This is exactly that.
Felony court. I mean, he goes back home. He goes back to felony court. The judge allowed him to amend the bond condition so he can go back to that residence.
Sure.
Yeah, that's when I spoke to DVD. But the problem was the MOEP was still in place when he went back to the house. So I think it's a violate bond condition and a MOEP. But since that time, I guess when he spoke to Judge Peebles, that he amended the bond conditions, removed the ankle monitor, and allowed him to go back home. In this court today, the violate the protective order is alleged to have occurred that the complaining witness went to the house where his mom lives to get her stuff because she was told she had to move out because her boyfriend now is in custody for a different offense. So she was asked to leave the residence. The mom didn't want her there. So she goes back to get her belongings. And that's when she encounters Mr. Powell's in the house because he's been living there with his mom. And so she does state, I think, in her, in the probable cause that he did not threaten her or he did not assault her, but here we are. I mean, it's a black letter law, right? So obviously, I think everything's going to hinge on the felony case.
Yes, Judge, and we have notes as well saying that the felony court did remove that condition. It's just uncertain why they didn't amend it in the MOAP as well, but the bond condition was removed after it was found the complainant no longer resided at the.
We're holding him at no bond too.
Right, so
I don't understand how
And then that's what I'm saying, and he does go back to court on the 19th
No?
for
I
the
mean,
felony.
with our case, the problem is that he's still in communication with her, which is still a violation, right? You can go back to the house, you just can't, I mean, and I'm assuming the only reason he could go back to the house is because she's in rehab and she's gone, right? But for her being in rehab, he still wouldn't be able to go there. Because I think the idea is that they don't have communication together.
And I think the
Problem
date
is-
was the February.
And
Yeah.
what I don't, the problem upstairs is they didn't try to anticipate if and when she would leave rehab to go back home, because if he's there, which he probably has nowhere else to go.
Right. According to our case, she was there to get her belongings, and that's whenever they came into contact with one another.
So ours is a good case then.
Yes, technically, because it's based on the MOA that wasn't amended, so,
No,
because that's, you know.
no, but they still are having contact.
Yes,
That's the problem.
Just as,
Not the fact that he's
just
over.
as pled.
Well, he lives there. She came over to get her clothes because she was kicked out. It's his mom's house of 40 years.
Right.
Yeah.
Right.
And then she came,
And his mom is a complaining witness.
no,
Who's a complaining witness?
Complaining witness.
he moved
a
in
roommate.
basically to crackheads to the house. And it's a guy and the girlfriend. And then the girlfriend had to leave. And then the boyfriend of that girlfriend, it's not him. So basically he moves in two buddies, two friends.
Right. I get that. So it says here,
And the woman is the girlfriend of the,
one guy.
yeah, one
So
guy.
that's Miss Scott.
Yes, yes.
Yes,
So that's Miss Scott's not.
not
It's
his
not-
mom.
not his
It's
mom.
not his mom.
Good.
So Miss Scott, those are the her clothes.
Either, I don't know, I can't tell from the pleadings and what I've read, if it was before she was in rehab, after she was in rehab, or during rehab, when she goes back over there to get her stuff, because it indicates that someone told her she could no longer live there.
So it says here, did violate said order by intentionally and knowingly going to or near a place specifically described in the order to a residence of a protected individual, namely this address, right? I mean, if you're telling me that it was amended to where he could go there, I'm gonna find no probable cause.
We understand because the bond conditions were
Right.
amended in the felony.
You want to take a look just to make sure? Because it will affect an upstairs case. Howell.
And Judge, what we have, and just to be clear, the bond conditions were
In place.
amended.
Yes.
The MOAC was not amended, and that's what this BPO is based on. Just to make sure that the facts are.
And then according,
There's two.
Was that an oversight on their part upstairs?
it appears
We
so.
don't know.
It may, probably was.
There's no note anyway.
But these bond conditions were amended for him to be able to go back to this.
To that same residence, Your Honor, yes.
And they removed his ankle monitor as well, so there was no exclusionary zone anymore.
And here's the rub though, they're holding him at no bond upstairs and then now for another 2 more days.
But the bond is removed. So,
I'm gonna find no PC. I mean, I can't,
This might be one I need to kind of go talk upstairs about.
do you want to email them real quick and see?
So
I mean, we haven't,
the DVD prosecutor did come down, and basically he was saying, obviously it all depends on the felony, but he also indicated that the MOAC was still in place when the alleged.
every right to be there because they amended the condition for him to be able to go back.
But I think they're saying the offense occurred before the amendment was made.
And here's the kicker: the violation happened before the bond conditions were modified. That timing makes all the difference. The judge can't just ignore the fact that Powell was at the house when he wasn't supposed to be. What do you think? Is this a case of bad luck, or someone pushing boundaries until they got caught?
That's a different story then.
Yes, Your Honor. And so
Say that they amended the condition.
sorry, Your Honor, the other thing is this is a,
February 14th, and this office date
Oh.
is.
So what happened is when he went to the location, he got a bond violation. And so he appeared in felony court after that, and they amended it.
But he's still nevertheless,
Right.
Your Honor, before, I just asked for before
I'm not
a
going to.
decision.
Because this is the date, but it's the date before the conditions were modified. He still is going there when he's not supposed to be there. Right, okay.
But I was asked if he would reduce his bond.
It's at $500 now.
I know, can you reduce it to 100?
Let's do this. I don't know yet because obviously he's still doing whatever he wants to do. And I have concerns, you know. Why don't we set this for the 20th, which is the day after felony court? Let's see what happens over there. And if they give him a PR bond and if they're okay with releasing him, then
Your Honor, this is a DVD case as well, and so I'll have the DVD prosecutor.
Okay. Yes.
Okay,
So
so we're gonna roll it to the
I
20th.
would say, yeah, Thursday's the 20th so that we can,
Sounds
you
good.
know.
All right, thank you.
I mean, if it was after, I'd find no problem.